Hi, welcome. My name is Michelle McKenzie. I'm a clinical care coordinator for the Greater New York chapter. Welcome to our webinar today. It is going to be on estate planning and Medicaid for New York. And I have the pleasure of introducing Mr. Elisha Wellerstein. He is an elder care attorney, founding principal of Wellerstein Law Group, and Elisha's focus is on estate planning and elder law. And with that, I'm going to hand it over to Elisha for his presentation.
Thank you, Michelle. Thank you, everyone, for joining. Thanks to ALS for inviting me again back to speak. It's always a pleasure to come and share some information to help some people guide while you're going through this stressful thing. So today's seminar is going to be on planning for long-term care, protecting your income and assets. So I'm going to pull up my PowerPoint here so we can all see what we're looking at. Okay. So we're going to be planning for long-term care and protecting your income and assets. This is part of a longer presentation, so we may skip some slides as we go through. All right, so go back. Okay. Sorry, we are having already some issues. Give me a second. Let me get in. One more time. All right. Okay, so that's what we're going to learn today. We're going to learn what a basic estate plan is, what long-term care is, what ways to pay for and for long-term care and the cost of long-term care, what Medicaid is, how to qualify for Medicaid, even if you have assets and your income is high. Just a little bit about myself, Elisha Wellerstein or Eli Wellerstein. We have offices in West Hempstead, Queens, Brooklyn, and Ronkonkoma. We also do home visits for our clients. We offer free consultations. I'm sure you can get our information after this. Along the way, please ask any questions. We have the different chat options, and someone's reading them, and they will reach out to us at the end and let me know your questions. So let's just talk about some estate planning. So the basic estate plan is going to be your will, power of attorney, and healthcare proxy. So I'm going to start with the will. The will is, as many people know already, is your last will and testament is where you're dictating what happens to your assets, how they pass, assets that are probatable, assets that don't have beneficiaries listed on them, like financial accounts, 401ks, IRAs, things like that. Those all pass outside of probate. The will would control the disposition of that. In your will, you're also going to name who your executor is, and you'll be able to make any recommendations to a holding of assets for any possibly disabled children or my beneficiaries, any charities, things like that. Without a will, the New York State has written you a will. It's called the laws of intestacy, and for many people, it is not the most important document. What really is the most important document for everybody, especially people going through a disease like this, is going to be the power of attorney and healthcare proxy. So let me just tell you, so your power of attorney is a legal document where you are appointing somebody to legally have the authority to make financial and legal decisions for you. You're appointing your agent. You can appoint one person or multiple people and some alternates. And you can give different authorities to be able to make gifts, financial planning, things like that. There isn't any sort of general power of attorney in New York. The law in New York is that if a power isn't specified in the document, it's not available. So it's always important to be working with somebody who does this type of area of law regularly. Off-the-shelf power of attorneys, whether from LegalZoom or from your stationery store, staples like that, those are usually pretty generic, and they'll allow you to do things like access bank accounts. But if somebody needs to do any sort of trust planning or Medicaid planning, gift transfers, usually those off-the-shelf power of attorneys are insufficient. So it's recommended that you work with an elder law attorney, creating your power of attorney, making sure it's as robust as possible, and so those authorities that are needed for the situation like this are part of it. Let's also talk about the healthcare proxy and other other medical orders and advanced directives. So in your healthcare proxy is where you're similar to the power of attorney, you're appointing somebody to be able to make healthcare decisions for you if you're unable to. It's really important to appoint the right person. Obviously, you want to make sure you appoint a person that you trust, that is in line with you in regards to medical treatment and life-sustaining treatments. You want to make sure that they agree with you morally, ethically, and religiously. We've unfortunately seen some drastic situations where client has appointed a child who may feel very differently about certain traditional medicine, or even religious beliefs, and there's been major conflict, and the wishes that they wanted to carry out weren't carried out the way they wanted to. So it's always important to make sure that when you are appointing your healthcare proxy, that you are appointing somebody that understands what you want. In your healthcare proxy, you can also make any references to organ donations and some life-sustaining treatments. You also have your MOST form, which stands for your medical order for life-sustaining treatment, and DNR. If a person is not in the hospital, they can fill the MOST form themselves. If they're in a hospital, they need their doctor to sign off. And those are documents where you are specifying what your wishes are. And you want to make sure that before you fill one of these things out, you speak to your doctor, to your social worker or geriatric care manager, to make sure you understand the ramifications of the restrictions you may be putting on. We've seen situations when people have put things down of they never want to be intubated, though when things carry out, it's a little different and it's not exactly as they wish. So I really recommend that speaking to a medical professional and understanding what those choices are and how they may play out, especially with a disease like ALS. You want to know, you want to get the most information so you can make an informed decision. So let's talk about long-term care. All right, so we went over the power of attorney, the healthcare proxy, and the basic stuff. Now I want to talk about long-term care because this is an area that's very relevant for everyone who's part of this. So long-term care is defined as, so let me tell you what's not long-term care. What's not long-term care is going to be a rehab stay. So a rehab stay is after a hospitalization, someone goes into a rehab center. Medicare usually covers the first 100 days. The first 20 days is 100%. Day 21 to 100, Medicare covers 80% of it. Your long-term care insurance, your secondary insurance may cover the 20% copayment, or you may have to pay for it privately. This is not called long-term care. This is called short-term care. Long-term care is described as any stay in a facility, in a rehab or nursing home for over 100 days, and also any services needed at home of a home health aide. Medicare does cover up to 90 days of care in the house of after someone's been hospitalized to get a certified home health aide to come in. Usually that's very minimal. It usually maxes out about 20 hours a week. And it's not a long-term solution. So Medicare is not something that someone can rely on. And let's talk about what those different types of long-term care and which care may be best for someone in different situations. So skilled nursing facility is licensed to provide skilled nursing. They're advanced medical services. They give rehabilitation and therapy. They provide meals, activities. There's a 24/7 nursing team on staff, and it's good for people with serious medical conditions. This would be a nursing home stay or a rehab stay for the short term, and if it's over 100 days, it would be a nursing home stay. A second type of a long-term type of care would be an assisted living. And assisted living is when you're still living in a community, you're not living in an institution. You are provided with assistance with medication, assistance with meal. There is 24/7 staffing. This is good for people who are aging but do not have serious medical conditions or injury. And there are many different types of assisted living. Some of them are large condo complexes, some of them in suburban neighborhoods. There are plenty in Manhattan, in Westchester, all over different types. The downside of assisted living is they usually don't allow someone to age in place. That means as someone's condition worsens and they're unable to ambulate themselves independently, they usually have to be transitioned either back home or to a long-term care facility. So somebody who is suffering from ALS, assisted livings usually aren't the best, aren't a long-term option. Another option is going to be home care. So home care is when a person is living at home. Care is given in the patient's home. The frequency of assistance can vary, from 4 hours a day. We've seen as a minimum up to 24/7, in-home care. The highest level of care for home care would be a split shift, which is 2 12-hour people coming in with no rest in between. Whereas the second high level of care is called the live-in. That's someone who stays in there for 24 hours a day, and the aide is off for 8 hours at night. Quite often we see this is a level of care that our clients who are suffering from ALS usually end up with. So depending on the level of care, home care can be the most expensive. We'll talk about costs in a second, but the home care is preferred for people who don't want to leave their homes but need help. Here in our office, we've actually seen home care being usually the best solution. At home, you're getting one-on-one care with a certified home health aide. It's your environment, it's your schedule, it's your food, it's your guests, it's all like that. Once you're going to a nursing home facility or anything like that, you lose a lot of independence. Usually the level of care is at best 1 to 15. So that's 1 staff member for about 15 residents. So you lose that one-on-one care. And then they're in charge of the scheduling, the food, who can visit, things like that. So quite often we see that people are not happy with nursing home, and they prefer to be at home if possible. So let's talk about the ways to pay for long-term care. So here are some options that people consider. There's Medicare, long-term care insurance, private pay, and Medicaid. So Medicare will not pay for long-term care. We put that on there just as a red herring. Medicare, as I said earlier, only covers short-term. So in a rehab center up to 100 days, and for home care for a maximum of 90 days. They do not cover anything longer than that. If a person purchased a long-term care insurance policy while they were healthy and younger, long-term care insurance could cover long-term care. If you're relying on your long-term care insurance policy for something like this, I also recommend having it reviewed by somebody to make sure that it has the benefits that you're hoping to. A big thing we've seen is some people purchased policies in the 90s that did not adjust for inflation. So at the time, a full day of cost of care may have been $150 or $200 a day, where today that rate's somewhere like $400 to $600. So people are relying on that, and without that inflation adjustment, which they may not have taken, we've seen them be very disappointed and have to do some very last minute planning. So if you're going to rely on a long-term care policy that you have in place, I really recommend either speaking to your insurance broker or an elder law attorney to find out if the benefits that you're expecting are actually what's in there. The next option is going to be private pay. We're going to talk about private pay and those issues. We'll go over here. So here's just a map. This is from last year. It hasn't been updated for 2023. This is the average cost of care for a nursing home in New York State. As you see there on the lower half, New York City, it's about on the low end, it's about $422 a day. That's about $155,000 a year. So even if somebody does have a significant amount of income and assets, usually these aren't any sustainable in the long term. And for home care, rates that we're seeing here for private pay in New York City, Long Island, it's $30 to $35 an hour is what we see people paying if they're going through an agency. Obviously, sometimes people skip the agency and go directly to an aide. You might be paying around $25 an hour there. And then other options, which aren't always recommended, are unlicensed and informal caregivers. That's something that you can plan out for yourself. 12 hours a day of care is usually costing about $350 a day. We see a 24-hour live-in is costing about $400, which if you do the math ends up being somewhere from $10,500 to $12,000 a month. Once again, this is usually something that is unsustainable for most families in the long term. So private pay is a hard option and not really something people can do for the long term. The fourth option, or the last option, the one that's usually the most favorable, is going to be, I'm sorry about the ringing, by the way, is going to be Medicaid. So let me tell you what Medicaid is, and I can go over the obstacles for Medicaid and the different types of Medicaid. And this is just a short summary, really, whether it's myself or an elder law attorney, another elder law attorney you deal with, they should be able to explain to you the different purposes and go into more detail specific to your case. I'll be giving some just general information. So types of Medicaid. So there's the New York State Healthcare Exchange. Also, that's also known as Obamacare. This is for people who are under 65 and not disabled. So that is, the regular Medicaid system. You someone to go and, someone who's not disabled and under 65, they would apply by themselves through New York State Department of Health. Another type of Medicaid is institutional or nursing home Medicaid. This is for somebody who needs to go into a nursing home. I won't go into so much detail about this one. The reason why is, one, generally we don't really recommend nursing homes if we can avoid it, but it's a more complicated situation. A nursing home Medicaid requires a 5-year review of a person's finances. It generally requires us to do planning 5 years in advance. It's quite expensive and time consuming. And so it's too detailed for a short presentation like today. The other type of Medicaid is community Medicaid. That is when you're living in the community, whether in your own home or in assisted living. And that's the one we're going to talk about. So what is community Medicaid? So community Medicaid is when someone is living at home and they're going to receive long-term care services. Medicaid considers long-term care service, the biggest benefit is going to be your home care services. Medicaid is here to assist in your ADLs, your activities of daily living. And starting just to give you some information of what those ADLs are, starting from waking up in the morning, it's assistance, getting in and out of bed, assistance of, getting to the bathroom, your hygiene, showering, bathing, dressing, or, getting down to your kitchen, preparing meals, if you need assistance feeding, doing, bathroom stuff, doing that throughout the day, and then reverse at home. And that's what community Medicaid is looking at and what their providing services are. So to qualify for Medicaid, Medicaid has a 2-part test. They have an asset test and an income test. So as we're going through this, if you have any questions, please just drop in our chat box and I'll be able to respond to it. I may cover it. So the 2-part test for Medicaid is the income test and the asset test. So let's talk about the asset test. So Medicaid has 2 different metrics they use. One is either for a single person or for a married couple, or if it's a single person who's applying with a spouse refusal. I'll go into that in a little bit. But as you see here, a single person is allowed to have roughly $30,000 in countable resources, and a married couple who is applying for Medicaid together is allowed to have roughly $40,000 in countable resources. So countable assets are going to be things such as, stocks, bonds, investments, brokerage accounts, a vacation home, savings accounts, checking accounts, life insurance policies, basically anything that you can access easily is going to be considered a countable asset. Let me tell you what's a non-countable asset. So retirement accounts, 401ks, any tax-deferred account that's in payout status is an exempt resource. I'll explain what a payout status is in a second. But so any tax-deferred account in a payout status, one vehicle, burial funds up to $1,500, prepaid funeral agreements, your primary home, as long as the applicant is living in that house, and the equity is under 893. And even though the home is an exempt resource, we're going to talk about why we may have to do some planning. So what doesn't count are those assets. What does count is going to be the other things, like I said earlier, your brokerage accounts, checkings, savings, and things like that. Tax deferred accounts and payout status. So how that's defined, New York State defines payout status is that it has to be in periodic distributions that are tagged to a person's life expectancy, normal life expectancy. So outside of New York City, there's a calculation, ends up being roughly about 5% a year you have to withdraw. If somebody is in New York City and they're over 72 and they have a required minimum distribution, then the RMD would be sufficient. As long as you take it out to RMD, you'll be considered in payout status. If somebody is under 72 years old, there is a calculation that we have to do. We create an artificial RMD to put it in payout status. Depending on your age, it's somewhere from 3 to 5%. So if a person has assets over if you're a single person of $30,000 or a married couple who's applying together of $40,000, then we have to reduce those assets. And there are a few ways we can do that. So one way is to gift it to family or spend it down. So gifting it to family, let's say, there are no ways to spend it down. We don't have any debts to pay off. We've already taken care of funeral arrangements, bought a burial plot, things like that. If we've done all those things and now we still have excess resources, one option is to gift it to the family. Usually these transfers are tax-free. No transfer tax is owed by either party. The pitfalls of making gift transfers is that money is no longer yours, it's gone. Any income earned from that money, it disappears. If the people you're gifting the money to want to spend it, they can. If they have any of their own financial issues or health issues, those are going to be issues. We've seen families gift things to parents who have college-age children, and those pitfalls have been there when they apply for financial aid and things like that. The parents have significant assets they weren't expecting, so there are pitfalls there. But also the pitfalls of if any people you're giving to have substance or financial abuse or financial issues, that money can disappear too. Another option, usually the one that's preferred, is to transfer the assets into a trust. By transferring into a trust, we're usually able to preserve some control over it. And I'm gonna discuss the different types of trust. So first, let's talk about what a trust is, and then I'm gonna talk about the different types of trusts. So a trust is a legal arrangement. It's a private contract, and there are three parties to every trust. There's the grantor or the creator. Those are usually the clients who are creating the trust. There is the trustee. That's the person who's in charge of the assets. And that, depending what type of trust we pick, is going to be either the grantor or someone else. And then there are the beneficiaries. And there are two types of beneficiaries. There are the lifetime beneficiaries. Those are the beneficiaries who benefit from the assets in the trust while the grantors are alive. And then there are the future beneficiaries, and those are the people who inherit the assets after the grantors pass away. The two types of trusts are revocable and irrevocable. These are big general umbrellas. A revocable trust, the benefit of a revocable trust is that it helps you avoid probate, and it gives you full access to the assets while you're alive. And the downside of it is there's no credit or Medicaid protection. So if somebody is creating a trust to make themselves eligible to reduce their assets and make themselves eligible for Medicaid, a revocable trust, whether they have one already or if they're planning on creating one, would not work. It would not be a valid, because since the grantors have full access to the assets within the trust, Medicaid deems those as fully available to them and count those towards those assets that we mentioned earlier, the $30,000 and $40,000 limit. So a revocable trust would not help with it. It does help avoid probate. I mentioned briefly earlier, probate is a legal process after someone passes away, and then they have a will, or if they don't have a will, that's called administration. Your family would have to go to court. Here in the 5 boroughs, you're looking at about a 12 to 15 month process. Outside of the 5 boroughs, you're looking at maybe a 9 to 12 month process. The legal fees also can add up. The legal fees are usually somewhere from $5,000 to $8,000 to do probate, whereas with a trust, you avoid all that. Technically speaking, the day after the grantors pass away, the trustee can start selling assets and take the steps necessary to wind down the trust. So avoiding probate is a big benefit, but for our purposes and for for most people who are listening to this, a revocable trust won't work because there's no creditor protection and no Medicaid protection. So what does work is an irrevocable trust. And the difference between an irrevocable trust and a revocable trust, main one is the grantors cannot be the trustees. They would have to appoint someone else. So often we see that to be a family member or a trusted friend. So some fiduciary. The trustee is the one who's in charge of the money while they're alive and in charge of the money and assets after they pass. Another caveat of the irrevocable trust is there's limited access to the assets that are placed in the trust. I apologize, there's some background noise. There's some construction in our building. I don't know if everyone hears that, but so you have limited access to the assets within the trust. Within the trust, for it to be Medicaid compliant, it has to be an income-only trust. That means that of the assets that are placed in there, the grantors can only have access to the income that the assets generate. They don't have access to the principal amount. So if a person is putting, let's say $100,000 brokerage account valued at $100,000 into their irrevocable trust, and a year into it, they want to access that money to buy a car or something like that, they wouldn't be able to do so in the irrevocable trust. They would only be able to access the income earned off of it. So it's important to make sure as you go through your planning to have understanding of what assets you have, what access you may need to these assets, and to understand the ramifications of transferring them into the irrevocable trust. The benefit that you receive by not being the trustee and having limited access to the asset is that what you get in return is you get creditor and Medicaid protection. This means that regardless of what you put into the trust at the time of passing of Medicaid, Medicaid cannot put a lien on any of the assets within the trust. There's no worry about a Medicaid payback provision. And this is all regards into community Medicaid. So whether it's your home, brokerage accounts, checking accounts, savings accounts, anything like that, by putting it into the irrevocable trust, Medicaid does not consider an asset of yours while you're alive, and Medicaid does not have access to ask for a payback after you pass away. So let's give an example. We have a person who's applying for Medicaid. They have a pension, Social Security. They have a brokerage account of $100,000, an IRA account of, let's say, $250,000, and a home. So if they wanted to apply for Medicaid, their home is not going to be an issue if the equity is under $900,000. Their IRA is not going to be an issue as long as they put into payout status. What is going to be an issue is your brokerage account and whatever they have in their checking and savings account. Let's say they have $30,000 in a checking and savings account. So the checking and savings account, we can leave them the way they are because it's under the $30,000 limit. The brokerage account, what we would do is we would recommend transferring that brokerage account into this irrevocable trust that's created. It would be a non-taxable event. So any sort of losses or untaxed capital gains, all those are preserved. The IRS does not see it as a taxable event. We put into the trust. After we do all that, the following month, we can apply for Medicaid. Medicaid would be aware of all this and would not count the assets within the trust to be theirs. I had mentioned earlier about a primary residence be exempt resource. And this is a big caveat. We see this a lot sometimes when our clients or clients come to us and they have done Medicaid, not through an attorney, either through a Medicaid service, sometimes through a hospital, social worker, or some Medicaid office. They'll do Medicaid. They own a house, and they were told that owning the house isn't a problem, which is correct. Owning a home valued under $900,000 of equity is not an obstacle to qualifying for Medicaid, though if you still own that home when you pass away and your family has to go through probate or administration to transfer the assets to their name, Medicaid is going to be a creditor to your estate. So planning is needed. So let's just emphasize that. If a person goes onto Medicaid and owns your home, they can get services. Let's say they're on Medicaid for 2 years, and Medicaid pays out $100,000 years of services. Now the family, comes into my office and says, okay, mom passed away. We need to move forward with her will. We do so. We would probate that will. Medicaid is almost guaranteed to show up as a creditor. There's a 7-month waiting period as a creditor to the estate. And they're going to say, we paid out, here's proof, we paid out $200,000 of medical services for Jane Doe, and we want to get reimbursed. So before the children inherit the house, Medicaid is a primary creditor. The home would have to be sold. Medicaid would get reimbursed 100%, and only then the family would be able to get their share. So even though owning the home is not an obstacle, you're basically just getting an interest-free loan to pay for the services. So what we recommend is creating that irrevocable trust, putting the house into the irrevocable trust, even though it's not an obstacle for qualifying. But if it's in the irrevocable trust after passing, Medicaid, there's the creditor protection. Medicaid would not have a right to seek reimbursement, regardless of how much money was paid out, as long as all the provisions in the trust were followed. And this is something that we've seen many, many times, a problem that happens. And if you are working with an attorney on this, your family would be correct in in pursuing legal action against the attorney for not giving the right advice. But if you're working with a non-fiduciary, like a Medicaid planning service, or just the Medicaid planning office in a hospital or in a nursing home setting, they don't have any fiduciary responsibility to advise you correctly, and those people are usually left holding the bag on that. Okay, so I mentioned earlier there was a two-part test. I said there was an asset test and the income test. And as we said earlier, just to review that, on the asset test, it's $30,000 for a single person, $40,000 for a married couple, in countable resources. Anything in the countable resource that's over that amount, we transfer it out. Now, in terms of the income test, let's go over on the second part is the income test. So there are income limits. This year, Medicaid or New York State raised those limits drastically. A single person is allowed to have $1,697 in income. A married couple is allowed to have $2,288 a month in income. What does count as income is really anything that you get, any income you get through the year. Almost everything is considered income. There are a few exceptions. Some of them are some veterans assistance are considered exempt resources, not all of it. Holocaust reparation payments are considered exempt resources. Those are I think the only two that I've seen. Other ones are very rare. So Social Security, pension, retirement account, RMDs, retirement distribution, any payouts, any annuity payments, any consistent support you're receiving from family, all those count as income. Anything over these limits, I'm gonna round them up to $1,700 and $2,300. Anything over that amount is called surplus income. So how does somebody overcome the fact that their income is over this amount and they still want to get Medicaid? So anything over that amount is called surplus income. And what Medicaid allows you to do is Medicaid allows you to shelter that excess income into something called a pooled income trust. As you see here, a pooled income trust is a special needs trust that's run by a charitable organization. Their sole purpose is to shelter the excess or surplus income of individuals on Medicaid, and then spend it on their behalf. They're governed by state and federal Medicaid laws. Medicaid is fully aware of this, and they ask for proof of this. So the way it works like this: let's say we have a scenario, we have a single person, their income is $3,697 every month. That means they're over the limit of $1,697 by $2,000 a month. So they have $2,000 of surplus income. Instead of paying that income to Medicaid or doing a spend down every single month, which is a really bad option, we are able to shelter that excess income into this pooled income trust. Every single month, the client is still receiving their full $3,697 into the checking account. There's an automatic withdrawal into their pooled income trust account of $2,000. Medicaid sees that transaction and sees they only retained $1,697 in their checking account, and based on that, they are eligible. Medicaid asks for proof of that all the time. They're eligible for services. That money that's put into the pooled income trust account, whether it's $2,000 or $10,000 a month, that money is available to pay any bills for the benefit of the member. So whether it's going to be rent, mortgage, cable bills, cell phone bill, water bill, property taxes, Ubers, or car insurance, anything like that, as long as Jane Doe, those bills in her name, the money that she puts into the pooled income trust account, the trustees of the pooled income trust account would be able to write out checks to a third party. Also recently, what's been common, especially with the pool trusts that we work with regularly, is that they now offer you the option of getting a prepaid debit card. So let's say someone's putting in $2,000 a month, but they want to have half of that, $1,000 a month, to be put on a debit card. So they would have a $1,000 a month debit card. They can use that card for their groceries, their incidentals, their Walgreens, CVS, and stuff like that. This way, they don't have to submit bills or a credit card. They're able to have direct access to it. So the pooled income trust allows you to shelter your excess income or surplus income, regardless of how much money your surplus is. Medicaid allows for it, and you have full financial benefit of your money. The only difference is you can't write out checks from that account. You can't make gifts out of the account. It can only be for bills paid to a third party. Okay. Whatever isn't spent in the pooled income trust every month carries over to the next month. The caveat there is that if that's accumulating at the time of passing, the pooled income trust, the whatever is left over in that pooled income trust, Medicaid forces the money goes to the charity that runs it. So we've seen some examples where our clients may have significant income in retirement income. So let's say someone has, let's say Jane Doe again has $10,000 or $9,697 in excess in income every single month. She's over the limit by $7,000 a month. Every month she would be putting in $7,000 in her pooled income trust. If her bills only end up being $3,000 a month, the issue is that she's going to have $4,000 excess that accumulates. At the end of the year, we're looking at $48,000. So, you know, the pooled income trust may not be for everybody if they're a high earner, or if their spending is a lot lower compared to it. There are some, you know, things we can do to reduce that, and we can pay taxes and things like that. But just that's one caveat people have to be careful of and understand. So let's just recap over that. We have the income test and the asset test. So as we said, it's a $30,000 for a single person on the asset side and countable resources, $40,000 in for a married couple. On the income, it's this year it's $1,697. Anything over the amount is surplus for a single person. For a married couple, it's $2,288. Anything over that amount is considered excess. If a married couple is applying for Medicaid, only one of them has to do the pooled income trust. Even though if one of them is a lot higher earner than the other, Medicaid only requires one of them to have the pooled income trust. Let me just go over some other things that I mentioned earlier, a spousal refusal. So we were talking earlier, I said earlier that Medicaid, if you're a single person or if you're married, there's also an option called spousal refusal. So New York State has a law that says that if a person is married, the well spouse is, or the healthy spouse is responsible for the sick spouse's financial bills and legal bills. So technically speaking, in New York, a healthy spouse has to use all their income and assets to pay down resources and to pay towards the cost of care. Obviously, this isn't always financially feasible, or nobody wants to really do that. So New York State allows you to do something called spousal refusal. So spousal refusal is basically where one spouse needs to go on Medicaid, and the other spouse is either ineligible or doesn't want to be, or their income and assets are too high, or they're younger and still working, or any of those situations, they would have to do a spousal refusal. The spousal refusal is a document you're signing where you're basically telling Medicaid, even though I'm married, my spouse is refusing to contribute their income and assets towards my cost of care, and I want you to proceed as if I'm single. Medicaid says, no problem. They'll process the application if you're single, and they'll start providing you services on that. The caveat is, and what you're signing away there, is that the other spouse, the well spouse, Medicaid reserves the right to seek reimbursement from the well spouse if they so choose, and ask them for contribution towards a level of care. So in New York, even though the law is in place, I have to say it doesn't happen very often. We've seen it happen less than 5% of the time when New York State actually seeks reimbursement, though the state is going broke, and that's possibly something that's going to change. It's just a policy and just enacting, or exerting a rule that's already there. There's no need to pass any laws, so it's very easy for a county to start enforcing that. If Medicaid were to seek reimbursement from the well spouse, it doesn't mean it's 100%. Chances, what you look for is if the person has enough income and assets. Currently, if the well spouse has income of $4,000 more a month, anything over $4,000 is deemed available income to pay Medicaid back, and 25% of that available income. So let's say we have a spouse whose income, the well spouse whose income is $5,000 a month, which means their income is obviously $1,000 over the $4,000 allowable. So they have $1,000 of income available to contribute towards, to pay back Medicaid. Medicaid would ask for 25% of that, $250 every single month, indefinitely, until the debt is paid back to Medicaid. Obviously, if someone's income is $10,000 a month, then that $6,000 would be a higher amount. Even after the sick spouse has passed away, if Medicaid has already sought reimbursement from the well spouse, they will owe that money until that debt is paid off. In terms of assets, if Medicaid is seeking reimbursement after a spousal refusal, they're looking at $70,000 of assets, of accountable assets, owned individually, or anything over $120,000 of. So in that situation, let's say we have the well spouse has $100,000 of assets, of accountable assets. Medicaid would say the first $70,000 is exempt, but that $30,000 is available to pay them back, and they would ask the well spouse to reimburse them for that. So the spousal refusal, even though it works, is not something that should be so easily used. It should be considered the ramifications. Even if you have to do a spousal refusal and Medicaid asks for reimbursement, it's usually better than paying privately out of pocket, because the Medicaid rates that Medicaid is contracted for with all the insurance companies is usually about 30 to 40% lower than if you were paying privately. So instead of paying $10,000 a month privately, you might be only paying Medicaid back around $6,000 to $7,000 a month. And you'd also be paying back over a payment plan that's usually better than paying out of pocket. But that's really detailed. Okay. Let's talk about some changes coming to in April 2024. So I mentioned earlier that Medicaid has a 5-year look-back period for nursing home Medicaid. For community Medicaid, there is currently no look-back period. What that means is, technically speaking, you could be a millionaire today. You can have all these assets. You can plan, create a trust, move your assets into a trust, or make gifts. The next month, you can apply for Medicaid, and Medicaid only cares the month that you apply and going forward. It doesn't do anything back. It doesn't do any look back. I'm sorry about that. And so there's that I'm sorry about that. There's that 5-year look back period. Sorry, there's no look back period currently. Starting in April 2024, there's going to be a look back period for community Medicaid. What that means is it's going to be a 30-month look back period. That means when someone is applying for Medicaid, Medicaid is going to ask for 30 months of financials, and Medicaid is going to penalize the applicant. Roughly speaking, for every $14,000 of assets that have been transferred out of someone's name, Medicaid won't pay for 1 month of care. So starting next year, and anybody who applies for Medicaid beforehand will be grandfathered in, or starting sometime April, possibly April next year, or maybe pushed off again. If a client is coming to us, and let's say they have excess resources of $140,000, and they transfer that money, whether it's to a family member or into a trust, they've now transferred $140,000 out of their name. Medicaid is going to see that in their 30-month look-back period and say, you've made a transfer, we're going to penalize you for the first 10 months of care, right? 10 times $14,000. And the family or the person would have to pay for care privately for the first 10 months. Obviously, as those assets get bigger, and if it involves a house and things like that, that number could be a big number. So anybody who is unsure if they need Medicaid, anybody who is considering knowing, or someone knows that they're going to need Medicaid but doesn't think they need it right now, I would recommend moving forward with that before April. This law really was enacted and was supposed to take place in October of 2020. Because of COVID, it was pushed off, and it's been continued pushing off. And right now, New York State has announced that they're going to enforce this law starting in April of 2024, but that may change. So really important, anybody who is looking to apply for Medicaid in the next 6 to 8 months, surely move forward with that. Better to get it in place and get grandfathered in than to wait for things to happen. Of course, there are going to be some workarounds, and there are some exempt transfers someone can make, and that's really too detailed for this. But just because someone didn't make the transfers, let's say somebody is, doesn't need Medicaid, and June of 2024 needs Medicaid, and in last minute, there are some things we can do. It may not just be as clean, and we may not be able to protect everything, but it's still something doable, and it's just it's more of a detailed conversation individually. So if a person needs care, now what? So now is the time to reach out to somebody, whether it's me, our office. We provide free consultations going over this. Reach out to an elder law attorney who's familiar with this. Don't just reach out to anybody. Lawyers, jack of all trade, master of none, really does apply to the law profession too. So you want to reach out to somebody who can walk you through this. Just to give you some scenarios, sometimes people call us, hey, we were looking to move out of New York, we're retiring to Florida, whatever. Realize that New York is the best place to get sick and need care in. Reason why is because here in New York, 60 cents of every dollar spent on Medicaid is federally funded. The other 40% is funded by the state. Other states, for example, Florida, does not contribute at all to their Medicaid system. So they're only spending 60 cents on the dollar that New York does over here. And that's why someone with excess income or planning like this would not get the same level of services outside of state. I'll quickly talk about just DIY solutions, why they don't always work. Michelle's jumping me off on here. Okay.
Hi. All right, so
Yeah.
I'm just jumping in because we do have a few questions
Go
about
ahead.
the presentation you already gave. So let me just hit you up with some questions, and then if there's some time left, we can sort of go over more. But some of the information that you covered, I'm going to work a little bit backwards. The money in the pooled income trust, can it be used for children or grandchildren's tuition?
No, it wouldn't be allowed because it's not considered your expense, right? That's a voluntary thing. So the pooled income trust would not be able to pay for somebody's income or anything like that.
Okay, so another pooled income trust question is the money left in pooled income trust following a person's death, does it remain with the charitable organization? And how long does a family have to submit bills to that trust before it goes to the charitable organization?
Okay, yeah, so Medicaid does require that the money left in the pooled income trust goes to the charity or paid to Medicaid. Some trusts will give you, 90 days. Usually we see they give you about 30 days to submit bills that were incurred while you were alive to pay it. What we usually see is that money comes in, money comes out every month. Usually our retirees, whatever retirement money income they have is usually spent. Plus that's $1,700 that $1,697 that remains in their pooled income, in their own checking account every month. That doesn't have to be spent, that can be saved, and there's no restrictions on that.
All right, so the takeaway for that is if you have a pooled income trust, you really want to use that money every month to pay your bills and not let it accumulate.
Correct, and that's why I said earlier, if someone if their income is way higher than their actual spending, it may not be the perfect solution for them.
Okay, all right, what happens if a wife or spouse of a patient inherited money and doesn't want to give it up?
I assume this is talking about if the wife inherited money and wants to go on Medicaid, how does she preserve that? So the only way she can do that is either gift that away to another family member or place it into a trust. But Medicaid would, if it's over $30,000 and it puts your resource over $30,000, it wouldn't allow someone to keep that. So they would have to do some planning to bring that down.
Right, or they just would be denied Medicaid.
Or they would just be denied Medicaid and they have to pay for care privately. Correct, obviously, yes.
Okay, all right. Going back to the beginning presentation, can a long-term care policy be retroactively adjusted for inflation?
No, I've never seen that option. I don't think it's possible. I mean, just check with your insurance provider, but I don't think that's possible.
Right, and so they're often capped on the amount of money that can be spent per day for the long-term care.
Right. When you buy a policy, they'll say the cost of care is X amount, and if they don't adjust for inflation, the ones we've seen that haven't are like $150 a day, where the cost of care is way higher.
Right, okay. All right, so here's another question. Let's see. Can Alicia clarify when a power of attorney and a healthcare proxy each go into effect? And if you have multiple healthcare proxies, if they work together when advocating for patient wishes, does one healthcare proxy take priority over the other, primary versus alternate?
So yes, okay, so let's talk about the second question. So with a healthcare proxy, your primary takes priority over it. Generally speaking, it's easier to, I recommend usually for logistics person to have one person in charge. With a secondary as a backup if they're unavailable. You don't want to put two people in because of this disagreement. It's just going to end up in court and it's only going to make the attorneys happy. With a power of attorney, once again, you can appoint you appoint a primary, you can appoint more than one primary. And then with you appoint more than one primary, you can either require that they act independently or they can act independently or they can act together. Logistically speaking, I usually recommend appointing one person to be able to be in charge. This way there's no conflict with the backup. It's a responsibility. It's not really a benefit. When it takes into effect is once it's signed, it takes into effect. the person who's signing the power of attorney, right, the principal doesn't lose their own authority. They can still make full decisions for themselves. They're just adding someone in addition. And if they lose capacity, then the agent is the sole person to make those decisions. Same thing with a healthcare proxy. You still have the full authority if you're able to make decisions for yourself. The agent only is able to make decisions if necessary, if you're unable to.
Okay, and then a power of attorney ends upon someone's passing.
Correct. The power of attorney, right? You only have the powers that the person who granted you. So once they've passed, they have no authority. So you also have no authority.
Okay. All right. To double back to one of the questions I asked you, we answered it if the patient inherited money, but if a spouse inherits money, but is not applying for Medicaid, so the well spouse inherits money, and not the spouse applying for Medicaid.
So that means they did a spousal refusal. So if Medicaid were to be seeking reimbursement from you, if your assets are over $70,000, they're going to ask for that to be available to pay them back. What people do in that situation is they may open their own trust. A person, for the spouse who inherited the money would open up their own private trust and then transfer the assets into the trust, and then that's protected. And if Medicaid did seek reimbursement, that's no longer their asset; it's in a trust. And the look back wouldn't apply to them because it was done after the Medicaid application.
Okay. All right. I think we've answered the questions here. So if there was the DIY portion, we have a few more minutes for that.
Sure. So I just wanted to go over, why the DIY isn't so good. You want to make sure you have the right documents. Sometimes you have the right you have good documents, but they're the wrong solutions. Like I mentioned earlier, a revocable trust would be a wrong solution for Medicaid purposes. Sometimes power of attorneys don't have the necessary provisions in there. We add a lot of modifications to making sure you can access retirement accounts, safe deposit boxes, things like that, making gifts, changing beneficiaries. So the DIY solutions don't always work out, though if you have one, we're always happy to review to tell you if it gives you the authority that you're hoping to. Another issue that I see sometimes is, I can do that type of attorney, jack of all trades. They do a little bit of real estate, a little bit of divorce, they can help you, all the stuff. This is really a specialized area. You're already paying for the services. So my recommendation is go for the person who does this all day, someone who regularly does elder law and estate planning. This way, you're getting the someone with experience, the most up-to-date advice. Our philosophy here is the right plan for the right solution. Each person is individualized. We really have to meet with each client. It's not a one-size-fits-all. We make sure it works for the family, and we make sure that people really understand what they're doing over here. In our philosophy in our office, we do things on flat fees. We do free consultations. We encourage questions. We encourage understanding of what we're doing. We'll visit the clients and at home or in a facility, anything like that.
I think what you just said about the flat fee is really important, especially with New York City and New York City prices. Can you just say what that means?
Sure. You want me to share my prices?
No, not show your prices, just what a flat fee means as compared to what
Sure, an hourly rate
can happen if it's not a flat fee.
Right. So an hourly rate, a lot of attorneys, you work with an attorney to apply an hourly rate. So obviously the more questions you ask or the more time it takes for a client to understand what the situation is, at an hourly rate, they're going to be billed for every phone call, every email, and things like that, which usually ends up being very prohibitive. Or what we've seen is that the clients end up just either not moving through with it or don't really understand and feel very frustrated. So we do, if you're hiring us, we do it on a flat fee. So as often as times you need help or you want to talk to your son and to your accountant or anything like that, we're always available. We're here to explain it and hold your hands through the whole process. We don't want the cost of things to be a hindrance to you getting the information that you need.
Okay, and also when a patient is applying for Medicaid, is it sometimes possible that you apply for both the patient and the spouse for Medicaid?
Yes, we generally, if they're both retired, I would recommend applying for both usually because it's the same cost, it's one application, and especially if they're seniors, this way we get them in the system already. If there's any changes in the future, they're grandfathered in, and it makes sense for them.
All right, so we finished a few minutes early, and I think I've asked all the questions. So what are the biggest takeaways for this year, 2023, going into 2024? You mentioned it, but I think it's worth mentioning again.
Right. So the big takeaway, first of all, is I know I went through this fast, is Medicaid is almost likely, almost for sure, an option for most people. In 10 years of doing this, I've had less than a handful of people who just didn't make sense. You know, their income was extremely high and their spending was really low. Other than that, it's almost available. So definitely speak to an elder law attorney, sit down for a consultation. Know that next year, starting April, it's going to be a lot more complicated. There's going to be a 2.5-year waiting period from when transfers are made. So if you or a family member has ALS, the reality is that long-term care is going to be needed. The next few months is the time to, you know, start taking action, move forward, speak to people, and get the process started.
All right. Well, thank you. Thank you very much, Alicia. It's always full of information. Did you want to put up your contact information? Do you have a slide for that?
Yeah, I do. Let me bring that up.
If not, they can always reach out to us and we can also provide them with your information for continual contact, ask questions specifically for them.
Yeah, so you can look us, you know, Wellerstein Law Group. You can find us online, 718-473-0699. It's wellersteinlawgroup.com. You can read our reviews, reach out to me. We have offices, like we said, and available. We make home visits, so we're here to help you and walk you through this tough time.
Excellent. Well, thank you. Thank you very much. Thanks for your time. Thanks for everyone who participated in this event. Remember also the ALS Greater New York chapter has social workers that you can reach out to as well in your regional area, who can also assist you with answering some of these questions and pointing you for an elder care attorney. So with that, we're gonna wrap up our presentation for today. Please join us for the next presentation, which is on nutrition at 4:30 with Cheyenne Tate. So we look forward to seeing you at the next presentation.
Thank you, Michelle. Thank you, everyone.
Yeah, thank you.